Good morning, everyone, and thank you for joining us today. It's great to see so many familiar names joining us, and a very warm welcome to those who are attending our webinars for the first time. We do hope that you'll continue to join us at our regular events in the future. Now, over the past few years, we've run two general immigration update webinars each year, one in the spring, one in the autumn. These broadly coincide with Home Office Statement of Changes cycles and allow us to keep you up to date with the latest and upcoming changes. My name is Imelda Reddington. I am partner and head of immigration here at Field Seymour Parks, and I'm joined today by my colleague Callum De Freitas, an associate in our immigration and employment teams. Today, we'll be taking you through the key UK immigration developments for 2026 and beyond, with a particular focus on employers and sponsor license holders. Now, you'll know the immigration landscape continues to shift quickly, not just in terms of the rules themselves, but in how those rules are being enforced. We're seeing in practice a system that's becoming more selective, data-driven, and far less forgiving on compliance issues. Now, today's session is designed to be practical, so not about what's changing, but what it means for you as an employer or sponsor and what action you should be thinking about now. So before we get into the detail, I'll just take you through a couple of housekeeping points. The webinar is being held remotely, so please bear with us should we experience any technical difficulties. We will aim to resolve these as quickly as possible. Our webinar today will be scheduled to be 1 hour. All attendees are on a mute throughout the course of the presentation. If you have any questions, please add them to the Q&A box on the portal, and we will endeavour to answer as many of these as we can. Any that we cannot answer or we need further investigation, we will aim to follow up with you by email afterwards. Now, as always, there will be polls throughout the webinar, so please do get involved with these. And the webinar has been recorded and will be sent to all attendees a little bit later today. Last point, we will have a survey at the end of the webinar. We would be very grateful if you would take a little bit of time to fill this out. Your feedback will help us with future events and topics. And as a thank you, those who complete it will be entered into a prize draw for our usual £50 John Lewis voucher. So moving through our topics for today, I will start with an overview of the immigration rule changes. Then I'll look more closely at sponsorship and compliance, which is where we're seeing the greatest risk for employers, driven by enforcement, audits, and action against licenses. I'll look then at what employers should be doing now and how we can support organisations through these changes and the proposed changes with the upcoming right to work expansion checks. Callum will then take you through the contentious topic of earned settlement proposals and citizenship. Alongside that, he'll briefly discuss changes to alternative routes to attract talent to the UK, particularly where sponsorship may not be the right fit. And he'll also cover the ETA, which is a visa waiver for the UK, and the EES, which has hit the press. These are waivers for Europe. He will focus on the practical impact of business travel and onboarding staff. And of course, at the end, we'll have some time set aside for your questions. So moving on to look at the changes from March. These changes were announced for March 2026, and one of the more notable developments is the increase in English language requirements across a number of visa routes. Now, in practice, this means that candidates who may have previously qualified are now facing additional testing to meet these higher thresholds. So migrants in the UK who are applying for settlement must now meet an A-level equivalent to the English standard. This is an increase from GCSE level or from B1 to B2 CEF4 levels. This applies to most settlement routes and mirrors the requirements that were introduced for many work visas, including the skilled worker in January this year. Applicants must evidence proficiency through a Home Office approved test or a degree taught in English. Now, there is still a bit of time for migrants to achieve this level as the requirement will come into force in March next year. Callum will discuss this in a little bit more detail later. As like the rest of the world, we're also seeing nationality-based restrictions to use more frequently. We've recently had a ban on all student visas from Afghanistan, Sudan, Cameroon, Myanmar, plus a ban on all skilled worker visas for Afghan nationals. These apply only to overseas applicants. And the reasoning behind these restrictions is that individuals from these nationalities are considered more likely to claim asylum in the UK once their visa expires. Interestingly, there have also been significant changes around suitability and criminality with a broader interpretation of what can negatively affect an application, including historic or overseas matters that previously have not caused any issues. So any foreign national who has received a suspended sentence of 12 months or more in the UK or overseas will now be refused or have their immigration revoked, regardless of when the offence occurred. And on top of that, there have been further fees increases, which continue to push up the overall cost of sponsorship and visa applications generally. Now, there are also multiple changes for sponsors that I will cover after our first poll. So moving on to our first poll, please. So it's a very simple question. For those who are present, are you a sponsor? Is it yes, no, or you're considering in the future? I'll give you a couple of moments to select your response. Wow, okay, we have 64% yes, 23% had no, and 14% considering in the future. So the next part of the presentation will be relevant for the vast majority of our attendees. So moving on. So the Home Office expectations of sponsors have increased again, with a clear shift from policy to achieve enforcement. Sponsors are now expected to be familiar with all parts of the sponsor guidance, not only the sections they use day to day. And the updated sponsor guidance published on the 6th of March applies to all sponsor license holders and any new sponsor license holders. It has an explicit duty that requires sponsors to read and remain up to date with the full sponsor guidance, which runs to hundreds and hundreds of pages. The Home Office also expects level 1 users, for those who are familiar with the term, or users, to log into the sponsorship management portal at least monthly to review message board updates. Now, we would normally recommend that users diarise access to the portal at the time of the license grant or any change in level 1 user. Now, this message board on the portal will also notify sponsors when any changes have been made to the guidance. So no excuse really in terms of complying with sponsor obligations. We regularly see license issues arising because organisations were unaware of the guidance updates. And quite often, this is as a result of users not accessing the portal. The second point is awareness of employment rights. Now, sponsors have a responsibility to comply with wider UK law. This has always been an obligation under sponsorship, including UK employment law. The guidance has now been updated to specifically require sponsors to ensure that their workers fully understand their employment rights. Now, this includes entitlement to national minimum wage, compliance with working time regulations, pension auto-enrollment, opt-in and opt-out, entitlement to statutory leave and pay, health and safety, trade union memberships, duties under the Equality Act, and how to raise grievances. We do recommend ensuring that employment contracts include this information, or alternatively, that your employees are given access to the employee handbook or relevant policy documents, together with a written acknowledgement confirming they have read and understood these policies. And sponsors must retain evidence showing that these employment rights have been provided, such as employment contracts, handbooks, induction or training materials. Since 8th of April, sponsored workers must be paid at or above the required salary in each pay period. The salary must always meet the occupation code for every hour worked. So compliance is assessed on over any 3-month period where the pay is monthly or less frequent, or any 12-week period for more frequent pay. This was previously assessed over a year. Now, the new rules will apply to patterns of pay where the pay varies between pay periods, where the pay periods are irregular or less than monthly, and the Home Office will assess repayments to employees for certain immigration costs too. So those now on fixed or regular monthly salaries that meet the annual requirements, they're unlikely to be impacted by this change. However, where the Home Office discover a salary has been artificially inflated to meet these immigration thresholds, they will suspend or revoke a license. It's a reminder, really, for sponsors to ensure that the salary stated on the certificate of sponsorship must be paid on an ongoing basis and that the payments must be made regularly through payroll. The Home Office and HMRC data sharing is identifying discrepancies between sponsored salary levels and payroll records. For sponsors, please remember to report any changes in salary that are different to the certificate of sponsorship because of statutory leave, such as maternity, paternity, or long-term sick, as this information is really easily identifiable now that the Home Office are sharing data with HMRC and other government bodies. There is also a new eligible role requirement, which replaces the genuine vacancy test. Sponsored roles must genuinely exist or be expected to exist at the point the certificate of sponsorship is assigned. It should accurately reflect the duties, hours, and job descriptions stated on the certificate of sponsorship, and it should also meet all of the immigration requirements, including the skill level and salary thresholds, which are available on the CASCOT database. So for those who are maybe not familiar with the CASCOT database, this is where you would look to assign a standard occupation code for the role you wish to assign to a migrant worker. It's good to do an assessment against your job description and the skills and levels that are assigned on the CASCOT database. And of course, the eligible role test would also expect the role to be appropriate to the size and nature of business. Employers must ensure that roles are clearly evidenced and genuinely required, that job descriptions, occupation codes, and salaries are fully aligned, and that the cause or the certificate of sponsorship accurately reflects the role that that individual is performing. The Home Office no longer needs to identify a technical breach before acting. If there is a reasonable suspicion of non-compliance, enforcement will follow. Now, with the added duty on sponsors to keep fully up to date with guidance, those who cannot show active compliance management are increasingly at risk. And issues that may once have resulted in an action plan are now leading directly to suspensions of or revocations of the license. We're also seeing an ongoing increase in Home Office enforcement. This enforcement is deliberate. The Home Office now monitors sponsors through real-time data, sharing information across government systems, rather than relying solely on inspections or requests for information. So minor discrepancies, particularly relating to salaries or failing to report changes in circumstances, can trigger significant action against the license. Active and ongoing compliance management is essential to avoid a suspension, revocation, or even a Home Office visit. I will look at enforcement action in a little bit more detail later. Now I'm going to move on to right to work. So right to work compliance remains a significant risk for all employers. There was a public consultation in December 2025 asking for input from businesses on expanding the right to work checks to all workers. Now, the outcome of this consultation is still pending. However, the legislation has been put in place for this legislation once the Home Office decide how to progress it. The Home Office do appear to be moving ahead with wider reforms in line with changes to the sponsor guidance, which I will cover in a moment. We've recently been asked to review the draft code of practice on avoiding discrimination while preventing illegal working. Now, whilst we don't know if this will bring about a full change to the employer's guidance on right to work checks, the guidance consultation documentation says that the changes are proposed for implementation from the 1st of October 2026, with guidance expected in June 2026. The illegal working regime currently relates to employees and their traditional employment relationship. However, we expect this to change to cover a wider category of workers, such as contractors, consultants, self-employed workers, individuals, and casual labour, and any other directly engaged individuals in the business at some point later this year. But we do hope to know more about this in June 2026. If the proposed changes do press ahead, we would recommend that employers now start to look at the types of arrangements that could fall outside general employment relationships, conduct an impact assessment, a refresh of training, just to ensure that those who are responsible for checking right to work, onboarding, etc., are familiar with what is expected of them should these changes be implemented later next year. Please do get in touch with us if you need any support. Now, moving on to the right to work checks for sponsors. Now, sponsors are already subjected to these expanded right to work checks. The guidance published on the 8th of April says that a sponsor must check that any worker you wish to sponsor, including a worker who is not your direct employee or any worker you otherwise wish to employ or directly engage. So sponsors from the 8th of April must carefully consider who their contractors are, any self-employed individuals, any secondees, or any other non-standard working arrangements. Now, we don't have a definition of directly engage, but we are seeking clarification from the Home Office before this obligation is rolled out more widely to employers, as I said, perhaps in October later this year. The safest approach for sponsors is to carry out right to work checks on everyone you engage, regardless of their employment status. Now, in some cases, it may be appropriate to rely on a right to work check carried out by the individual's direct employer and retain evidence of the check. However, your organisation must be satisfied that the check is genuine, has been carried out correctly, and complies fully with the Home Office guidance. Most visas are now digital, and there is heavy reliance on digital status checks. However, this only provides protection where checks are accurate and properly recorded. Even if technical errors are now being picked up, for example, we're seeing problems where employers rely on an individual status page rather than carrying out the correct employer right to work page. Record keeping is critical. And we are also seeing license risk purely on missing or inconsistent documentation, even where someone has the right to work check. We would urge all employers to retain screenshots for the right to work checks carried out, particularly where a visa application is pending. The digital right to work check now contains a statement where it has recorded a visa application has been submitted but not yet decided. It's really important that employers would have a screenshot of that on file to retain a statutory excuse and avoid a civil penalty. It is an area that's often overlooked. In practice, right to work checks are often the entry point for a much wider audit, whether this is in the context of sponsor compliance, a sponsor license application, or even a request for an additional allocation of certificates of sponsorship for existing sponsors. I'll move on now to enforcement trends. So as discussed earlier, I will look at the trends as this has really been a defining feature of the last 2 years. Sponsor license revocations are at record levels. In the final quarter of 2025 alone, we saw over 1,500 licenses revoked, taking the total in the year for 3,100. That's more than double what we saw in 2024, and it is a significant increase compared with 2023. Now, the most common reasons continue to be underpayment of migrant workers, exploitation, failing to meet reporting requirements, and we're seeing a particular impact in some sectors such as adult social care, hospitality, retail, and construction. The Home Office is taking a much wider and more robust approach across all sectors. In practice, we're often seeing licenses revoked for issues employers previously considered administrative or low risk. So the key takeaway is that active ongoing compliance management is now essential. The Home Office also has significantly increased enforcement activity to tackle illegal working. In 2025, there were nearly 13,000 compliance visits, resulting over 9,000 arrests of individuals. Now, most of this activity continues to focus on sectors, retail, hospitality, and the beauty sector, but we are also seeing a growing increase in enforcement activity in construction and residential addresses. The figures point to a clear shift towards visible high volume enforcement. Site visits and arrests are rising sharply, and illegal working enforcement now sits alongside sponsor compliance as a core Home Office priority. Now, this would help to explain why right to work checks and record keeping has been scrutinised so closely, and even why relatively small failures can have significant consequences both to employers and sponsors. Employees should expect more frequent and increasing unannounced audits, so maintaining accurate records is important. Now, as I mentioned earlier, the Home Office relies heavily on data sharing across governments, particularly HMRC, PAYE and DWP records. Salary and working pattern discrepancies are being identified without the need for site visits or even requesting information from businesses. These inconsistencies between HR records, payroll data, and even sponsorship management migrants' visa applications are being addressed as non-compliance issues. Moving on to look at civil penalties being imposed to businesses. So for those of you who attended our talk in November last year, I presented this data. I've now updated it to include data for the end of 2025. So the chart shows the penalties over the last 2 years, and you'll see the number of fines. So we have this fluctuation across the overall penalties. However, the average is remaining very, very high at about 56,000 per person. A few years ago, penalties were typically around 10,000, but the average fine now is remaining at around 55. We saw a peak in Q4 of 24 to just under 60,000. But it also shows us that many businesses are receiving the maximum penalty, which is up to £60,000, which usually only applies for second offences or where no mitigating factors apply, like robust HR processes. So even in periods where fewer penalties have been issued, there is a substantial financial impact on individual businesses. In the most recent period, the Home Office combined quarters 3 and 4, which is much, much lower than previous periods. However, we saw one fine of over £300,000 issued to a business in the construction sector. So while we are definitely seeing a drop in the number of penalties being issued, the consequences when things go wrong are pretty serious, and fines in excess of £300,000 could severely put businesses at risk, and indeed a sponsor licence. So I'm going to move on to our next poll. So how confident are you that your business is compliant with their right to work obligations? Are you very confident the Home Office can rock up at any time? Pretty confident, you would need some notice if they decided to visit. Not very confident, you have some processes in place, but it's all a bit disjointed and you've been putting an audit on the back burner for years. Or the final choice, completely unprepared, you wouldn't answer the door if the Home Office knocked. I'll give you a moment to choose. Oh, I'm delighted to see that we have 0 and they're completely unprepared. Thank you very much for sharing that with me. So I'm going to move on to what employers can be doing now. So firstly, we strongly recommend auditing your right to work processes proactively. With the proposed expansion of right to work checks to all workers, it is important to understand how these additional requirements will affect working arrangements and your onboarding processes. Secondly, review salary payments carefully, particularly for sponsors, so including the timing of any deductions, any unpaid leave, or any variations in the standard salary, particularly against what's reported on the certificate of sponsorship and the visa application. And thirdly, ensure onboarding, HR and payroll systems align. Any inconsistencies across internal systems happen to be one of the most common causes for compliance failure. Sponsors have a little bit more to do. They should be ensuring that all roles meet the new eligible role test. They audit their job descriptions, their certificate of sponsorship details, and any salary payments. They obviously review their HR and right to work processes. They also ensure sponsored workers receive and acknowledge employment rights information, and that's been retained on their sponsorship file or HR file, and a refresh of internal compliance training and reporting procedures. Just a final note, sponsors should be treating compliance at a board level risk, not just a task for HR personnel. So how can we help you? Well, we do work closely with organisations. We support employers through compliance audit, gap analysis, helping to identify issues before the Home Office does. We provide practical training for HR teams and operational teams. And we offer ongoing strategic support, helping businesses to adapt their immigration strategy in line with any immigration requirements and recruitment needs. And now I'll hand you over to Callum, who will look at the earned settlement and other details. Over to you, Callum.
Thank you, Imelda. There are several significant immigration changes coming into effect over the next 12 months. Firstly, and as was initially announced in 2025's Immigration White Paper, the length of stay on the graduate visa is being reduced from 24 months to 18 months. Now, for those of you who aren't familiar with the graduate visa, this is a visa that becomes available after someone on a student visa completes their studies, allowing them to live and work in the UK for a further period. Now, this change will affect all those who apply for their graduate visa on or after the 1st of January 2027. In practice, this means that the current cohort of students in their final year of studies will be unaffected by this change. But those graduating from 2027 onwards will only be able to get a graduate visa for an 18-month period. Now, I should make clear that for those who have completed a PhD, the length of a graduate visa is 36 months, and that is not changing. Now, the Home Office have said that the rationale for reducing the period of the standard graduate visa is to encourage graduates to look for and obtain high-skilled employment sooner. But this change will also mean that employers will have less time to review the performance of graduate visa employees, potentially rushing them into a decision on sponsorship before they've had the opportunity to assess the individual's suitability for continued employment. Now, I mentioned this in November's webinar, but it is worth noting that the high potential individual visa, and that's a visa available to those who have graduated from world-leading international universities outside the UK, that has retained its 24-month length of stay. And the Home Office is also doubling the number of eligible institutions, that's the list of universities that applicants need to have graduated from in order to qualify for the visa. And that, of course, greatly widens the scope of possible applicants. And taken together, these changes to the graduate and high potential individual routes may have the unintended consequence of the best international students choosing to attend a university abroad rather than study in the UK, so that they can apply for a high potential individual visa, as they can then stay on this visa and work in the UK for an additional 6 months when compared to the graduate visa. And that may, of course, have a knock-on impact on the income of British universities, which are already under increasing financial pressure. Now, Imelda has already mentioned the English language changes that came into effect in January of this year, but there are further changes coming early in 2027. The general standard of English language required to apply for indefinite leave to remain is set to increase from CEFA level B1 to CEFA level B2. Now, like the changes to the graduate route, this was first proposed in the government's Immigration White Paper from last year. This change comes into effect on the 26th of March 2027, and therefore all applications for indefinite leave to remain which are submitted on or after that date will need to include evidence of the applicant's knowledge of English language at or above CEFA level B2. Now, it is worth noting that the existing English language exception for nationals of certain majority English-speaking countries, such as Australia, Canada, that will still apply. And so nationals of those countries will still not need to demonstrate their knowledge of English. So for those who are expecting to qualify for indefinite leave to remain after March 2027, this change to the rules may necessitate taking a new English language test at CEFA level B2, as an old B1 test will no longer be acceptable as evidence. And we expect that this change in language standards is likely to catch some applicants out, although in some circumstances, the Home Office may offer applicants additional time to take a new English language test and to provide evidence of this. Now, on the topic of indefinite leave to remain, the most significant changes anticipated for later this year are those planned for settlement, and we'll move on to consider those now. Now, we covered the government's earned settlement proposals at length in our annual immigration update from November 2025, and that is still available on our website. And if you do have questions about earned settlement, then I would recommend watching that webinar and reading our FAQ article, as these cover the proposals in more detail than today's session will allow. But to summarise, the earned settlement proposals would see the standard qualifying period for indefinite leave to remain, or ILR, increase from 5 years to 10 years. Now, as set out in the consultation paper published last year, this change was proposed to apply retroactively, meaning that it would also apply to those who are already in the UK on the path to settlement. Now, the consultation paper did set out options for reducing the qualifying period in certain circumstances, subject to meeting higher salary requirements, working in certain sectors, volunteering, or demonstrating knowledge of English language at C1 level. Although the consultation paper also indicated that some people may have to wait as long as 15 or 20 years to settle, depending on their job and immigration history. Now, the reason that I recommend watching our November webinar and reading our article from around the same time is that, in truth, not much has changed since then. We still don't have any outcome or update from the Home Office's earned settlement consultation, which closed in February, and which was meant to inform the final earned settlement rules. The only tangible announcement on earned settlement has come from the Home Secretary, who confirmed in March that the changes to indefinite leave to remain will be implemented sometime in autumn 2026. Now, that is somewhat later than was initially expected, but it does mean that we now at least have some clarity on timescales, although autumn obviously covers quite a wide time frame, and it is likely to leave those people who are expecting to qualify for ILR in September, October, or November of this year with some uncertainty as to what rules will apply by that time. Now, unfortunately, we still do not have any timeline for when further details of the final rules will be published. Without this, those currently on the route to settlement or hoping to apply for a visa soon don't have any certainty about when they are likely to have more information, which obviously makes future planning difficult. Now, we would hope that these details are published well in advance of the new rules being implemented to allow people time to plan and prepare. That said, the current government have thus far demonstrated a propensity for announcing and then very quickly implementing immigration changes. So I would not be at all surprised if the detail of the rules was announced in early September, for example, with implementation occurring by October. Now, it is worth noting that there has been some suggestion that the Home Office may backtrack on their plans to apply the earned settlement changes retroactively, with some leaks to the media indicating that Labour ministers and backbenchers are pushing back on this. Now, that would mean that those people who are already in the UK may not be subject to the new rules after all, although to be clear, we don't yet have any official statement to support this, it's merely rumours. A possible alternative or compromise could be the use of transitional provisions, which could make the new rules less onerous for those who are already in the UK and close to qualifying for ILR. For example, by allowing those who have got 4 years residence by autumn 2026 to still qualify after a total of 5 or 6 years, rather than being subject to the new 10-year qualifying period. Unfortunately, this is just a guess at what the transitional provisions could look like, as we don't have any details on these yet. This uncertainty about when people might be eligible for ILR is particularly worrying, as Reform UK have made clear their plans to scrap ILR entirely if they enter government after the next general election. Now, to be clear, that would include rescinding ILR from those who currently have it, except for those with settled status under the EU settlement scheme. It's also been suggested that Reform intend to replace ILR with a new visa requiring a minimum annual salary of £60,000. Now, because of this, hundreds of thousands of people with ILR could suddenly have their supposedly permanent residence rights revoked and be forced to leave the UK unless they can demonstrate annual income at these high levels. Now, we expect that the rumoured £60,000 salary threshold may also end up applying to citizenship applications, as it would seem strange if reform were to impose this requirement on an impermanent visa, but not on permanent residence and nationality. And therefore, in the event that Reform UK win a majority at the next general election, somebody who currently has ILR and who would be eligible to apply for citizenship under the current rules could suddenly find themselves not only unable to apply for citizenship, but also without any rights of residence in the UK at all. Now, at the time of this webinar, Reform have led every single general election poll conducted since May 2025 by a clear margin, except for one in which they were tied for first with the Greens and the Conservatives. We are therefore encouraging people to start reviewing their position and considering when they might be able to apply for British citizenship, as this may be the only way to protect your UK residence rights going forward. Although the next general election is not expected until 2029, most people must hold ILR for 12 months before they can apply for citizenship. So it may be worth obtaining ILR as soon as possible, particularly with the earned settlement changes coming soon. For employers, the changes to earned settlement later this year, together with the scope for reform to scrap ILR in 2029, may lead to non-British workers leaving the UK in high numbers, whether out of choice or otherwise. That in turn is likely to mean significant workplace disruption and a need for a greater focus on recruitment. More widely, we can expect to see a fall in the labour supply, putting inflationary pressures on wages. I wanted to now turn to our third and final poll of the day, as I'd be interested to know whether any of your employees are likely to be affected by the earned settlement changes and whether you've had the opportunity to discuss these changes with them yet. So please select option A if some of your employees are expecting to be impacted and you've already discussed the changes with them. Option B if some of your employees might be impacted, but you haven't had the chance to discuss the earned settlement proposals yet. Or option C if you don't think any of your employees will be affected. And it's worth keeping in mind, of course, that employees may have family members, for example, who are looking to apply for ILR or already have it. So I'll give you a moment to record your response to this poll. Okay, so interesting results. So the majority of saying that they do expect some of your employees to be impacted, but you haven't had the chance to discuss the earned settlement proposals with them yet. I would say these are obviously very significant proposals that are going to have a significant impact on a lot of people. And so if you do think that some of your employees might be affected, it's perhaps worth having that conversation with them, making sure that they're aware of the proposals in the first place, and perhaps ensuring that they are seeking advice or at least making themselves aware of the current position and when they can expect to have more news. It is going to be something that people are going to want to plan for, going to want to prepare for, and that includes businesses as well as individuals. With that rather sobering topic out of the way, I wanted to look ahead at some further immigration-related matters to keep in mind over the coming year. Now, having just touched on the topic of citizenship, the current Labour government have mentioned that they are in the process of reviewing the existing rules on citizenship and that they may look to change these in due course. However, we expect that the earned settlement changes will be the priority for the time being, so we aren't expecting any news on changes to the rules on citizenship until 2027 at the earliest, and we would expect any such changes to encounter similar delays as we've seen with earned settlement. Meanwhile, the Migration Advisory Committee, or MAC, are currently reviewing how the immigration system can be used to attract top international talent to the UK. Now, as part of that review, the MAC are seeking feedback on the global talent and innovator founder routes. Now, as it stands, the global talent route allows leaders and potential leaders in academia, the arts, and digital technology to come to the UK. But applicants must have either received an eligible prize in their field or successfully apply for an endorsement from an approved endorsing body. The innovator founder route, on the other hand, is available to those who want to come to the UK to establish an innovative business, but the business must be different from anything else on the market, with clear evidence of scalability. and the business plans must be approved by an endorsing body first. Now, while both of these routes can be useful options in certain circumstances, the narrow constraints of eligibility and the hoops that applicants are required to jump through with endorsing bodies are likely putting off or outright preventing some international talent from coming to the UK. Further to their review, the MAC may recommend loosening restrictions on these routes, potentially opening them up to a wider class of individuals or making the application process less onerous. Subject to any MAC recommendations and Home Office policy changes, these routes may become an increasingly attractive option for skilled individuals, especially where they do not want to be tied to a particular employer through sponsorship. It may also give employers in certain sectors another pathway to hiring highly skilled workers from overseas without the need to sponsor. With higher salary thresholds and increasing scrutiny on skilled worker sponsor license applications, we are continuing to see a pivot in Home Office policy away from general work immigration and towards targeting highly skilled individuals in particular sectors. An existing route that perhaps does not get enough attention, but which provides another alternative to the traditional work routes, is the Youth Mobility Scheme. Now, this is a route which enables young nationals of certain countries to come to the UK to live and work for a period of 2 or 3 years. For most of the countries in the scheme, the maximum age to apply is 30, but this was increased to 35 for nationals of Australia, Canada, New Zealand, and South Korea back in 2024. The Youth Mobility Scheme's relative lack of evidential requirements, combined with the flexibility of being a route that does not require sponsorship or endorsement, can make it a very attractive option for individuals and employers alike. And we do believe that this is an underutilized route, particularly for employers looking to hire from overseas. So if you have any questions on this, please do get in touch. I should add that there has been some talk of introducing a new youth experience scheme to cover EU countries, and it's our understanding that the government is keen to have this in place by the end of the year. However, the UK and the EU remain quite far apart on several key issues, which may end up scuppering negotiations. In particular, the UK government's preference is for there to be a cap on the number of people that can enter the UK under this scheme, and that's something that the EU are firmly against. And as those who have recently travelled to the continent may be aware, the EU's new entry-exit system, or EES, is now in effect. The EES requires visitors from non-EU countries, including the UK, to register their personal information and biometrics at the border. Now, perhaps unsurprisingly, this has resulted in delays at airports of up to 3 hours. And as just one example from earlier this month, there was an EasyJet flight from Manchester to Milan, which left behind over 100 passengers following EES-related delays. Now, the EES is the precursor to the EU's long-awaited European Travel Information and Authorization System, or ETIAS. ETIAS will require those visitors to the Schengen area who don't need a visa to instead obtain an ETIAS waiver prior to travel by filling out an online form. As part of applying for an ETIAS waiver, individuals will need to provide their personal information, including relevant criminal offence history, which will be checked against international databases. ETIAS is expected to come into effect in late 2026, although there is supposed to be a 6-month grace period after implementation. And during that grace period, you can obtain an ETIAS waiver, but will not be required to. Now, the ETIAS is likely to be quite similar to the UK's Electronic Travel Authorisation, or ETA. Since April 2025, the ETA has required all non-visa nationals, and that means people who do not need a visa to enter the UK, to first apply for an ETA before visiting. An ETA is obtained through an online application and remains valid for a period of 2 years. So if you've got people visiting your organisation from Europe or the US for business travel, you may want to flag ahead of time the need for them to get an ETA, as we expect that some people who are used to relatively frictionless entry to the UK may still not be aware of or prepared for this change. Well, that's all for today's talk. Thank you for everyone who's attended. Imelda and I are now going to hold a quick Q&A session to answer any questions that you might have. Imelda, I don't know if you've had the opportunity to look at the questions as they've come in.
Yes, I have indeed, Callum. We have a couple of questions here. I will let you while you're still speaking, unless you want to break, I'll deal with the first one. Actually, I'll deal with the first one and I'll pass you over to the second one. So we've had an inquiry about third-party vetting, including right to work checks, and that whether that is sufficient summary to retain on file for their employees. It's important to understand that a third party cannot pass on the liability for a civil penalty or indeed a statutory excuse to an employer once the right to work check has been undertaken. It's still the employer's responsibility to ensure they check the information thoroughly, they check the photographs against the individual who shows up for work, because that statutory excuse is retained only by the employer, and only the employer can be liable for that fine should that person not have a right to work check later. We have another question in relation to, this is for you, Callum. It's whether or not Anna actually has a dependent whose partner is on a skilled worker visa and wonders if the rules will apply to those already in the UK on a skilled worker visa.
Yes, so based on the consultation paper that came out last year, our current expectation is yes, people already on skilled worker visas, dependents on those visas, they would be subject to the new rules. Now, as I mentioned, there have been rumours to suggest that the Home Office may backtrack on this, that the position may change, and that either they won't apply the rules retroactively, so it only apply to people getting visas entering the UK after the rules come into effect, or that transitional provisions will be put in place so that there'll be some kind of grace period, for example. But as it stands, I would expect that there will be retroactive application of the rules, so people who are already in the UK will be affected. One thing to mention, though, is that, again, this is based on the consultation paper and it's all potentially subject to change. But our strong expectation at the moment is family members of British citizens, they would not be affected by the changes. So they would still have the same 5-year route. So partners, for example. But yes, for dependents on skilled worker visas, for example, our current expectation is that they would be subject to the new rules, even if they've been in the UK for 2, 3, 4 years when the rules come in. But we are, of course, keeping our ear to the ground and hoping to hear more from the Home Office, because obviously people want to plan ahead, want to know what rules will affect them, and we are waiting for further details. So once we have those, we'll publish an update on our website.
Okay, thank you, Callum. We have another question from Darren, which was partially answered by your last response, Callum. He's asked if there's any impact to colleagues who are in the process of marrying a British citizen. Whilst the settlement or the term to settlement may not be affected, there are English language requirements that may impact depending on their nationality. And these are due to come into force in March 2027. So it's worth looking at whether their nationality requires an English language test in order to apply as a partner to a British citizen.
And I suppose the other thing that I would mention about partners of British citizens is, yes, while we are expecting the 5-year route to remain in place, if that person, for example, is switching from a work visa, they will restart their 5-year period. So let's say somebody's on a work visa at the moment, they're thinking, I want to get off that and get on a spouse visa so that I'm not going to be affected by these changes. You then restart your 5 period now, which would, of course, run to 2031. And as mentioned, our understanding, if reform were to get into government after the next general election, that their plans are to scrap ILR. And I read a statement or an interview where Nigel Farage even said, we acknowledge that this is going to break up families. So I wouldn't expect there to be an exception for people who are married, for example, family members, etc. The position at the moment seems to be they would get rid of ILR entirely. And so somebody in this scenario who's switching to a spouse visa now would find themselves in a position where potentially they're having to apply for a visa at, as I say, this is just rumoured, but potentially a £60,000 salary threshold. That later bit is not official policy as far as I'm aware yet, but it is something, again, that we've heard leaks to the media. It sounds like that might be the direction of travel and that might be what's replacing ILR if reform were to get into government.
Okay, I think Callum, you're preempting the questions. The next question is, would you recommend someone
Mhm.
currently on a skilled worker visa switch to a spouse visa if they're married to a UK citizen?
Yeah, and I think it will depend on individual circumstances,
Sure.
and far be it from me to tell somebody what to do over a webinar because it's something that we'd ordinarily recommend that you get advice on. But I suppose the risk is if you're on a skilled worker visa at the moment, yes, the current expectation is that the new rules will apply retroactively, and so your wait for settlement could be extended to 10 years. But as mentioned, there are ways that you can reduce that wait. So hitting certain salary thresholds, volunteering, working in certain sectors, higher English
Sure.
language standards, etc. So that's something to consider. And the other thing to consider is that we don't know for certain that the new rules will be applied retroactively. We don't know for certain whether there will be any transitional provisions. And so it is possible that if that person were to stay on their skilled worker visa, they may be able to settle before, if the Reform Party do get in, before they get in and scrap ILR. Of course, the timings of that you need to be quite careful with because you could obtain ILR, but that could be then rescinded quite quickly. So making sure that you can also get settlement potentially before reform gets into government is an important factor to consider. My concern with switching to a spouse visa now is that, of course, you reset your
Your
route,
clock.
have to wait 5 years,
Hmm.
and therefore the very earliest that you could get settlement would be 2031. And so there's no possibility that it doesn't matter whether the new rules are or aren't applied retroactively. It doesn't matter whether transitional provisions are put in place. You are stuck with that 5 year wait, and therefore you would have to hope that reform don't get into government at the next election, or that for whatever reason they delay in scrapping ILR until after 2031. So a lot of thoughts there, a lot to consider. As we say, because this is there's so many unknowns about the earned settlement rules, we are really hoping that the Home Office will publish further information soon, particularly on retroactive application and transitional provisions, so that people can plan accordingly.
Hmm. Note there are lots of legal challenges against these changes to apply retroactively, and we have not had any formal response of these. But I know organisations are still pushing ahead with the challenges. So hopefully we will have some transitional provisions in place for those who are already here, particularly those who are very, very close to that 5 year settlement period. But we need to wait and see, I'm afraid. Panagiotis, you have your hand up. Did you want to put your question in the chat so that we can respond? Or perhaps you didn't realize you had it up. Let me just check and see if we have any other questions in the meantime. Okay, that's fine. Thank you. We have one other question, and it's relating to how the Home Office spot errors with without having to visit or ask for information. Well, as I mentioned in my presentation earlier, the Home Office now have immediate access to HMRC records, PAYE records, and these are automatically checked against sponsorship records in particular. However, for those who are not sponsors, the payroll information that's submitted to HMRC could have areas that would highlight potential problems, such as somebody who doesn't have a visa, yet they have a nationality that requires a visa. So it is important that businesses are not paying visitors in particular, or those who are not eligible to work on certain visas in the UK, because this again would automatically be picked up by the Home Office with exchanging information with HMRC.
Just
One
one other
other
question.
question,
Yeah,
can you see it? How is
yeah,
the
about the
European
new
settlement
settlement.
status
Yeah.
affected?
So to answer that question, the earned settlement changes will not affect
Yeah,
people on the EU settlement scheme. And also, Reform have said that their scrapping of ILR also wouldn't affect
perfect.
people
Yeah.
on the EU settlement scheme with settled status. I suppose the only thing that I would say on that, and the reason for that, just to clarify, is because the EU settlement scheme is something that came out of the withdrawal agreement with the EU. And so it would be a diplomatic nightmare for them to try and go back on that. Now, the only thing that I would say on that later point is if somebody had said 5 years ago that you know, changes to indefinite leave to remain might be applied retroactively to people already in the UK, it would have sounded absurd. Similarly, if somebody had said 5 years ago that indefinite leave to remain might be scrapped across the board and rescinded from people who already have it, it would also be considered absurd. So, it does feel as though increasingly um, anything is possible in terms of immigration changes. And so, whilst I wouldn't I wouldn't be worrying about it right now because there hasn't been any indication that there are any plans to breach the withdrawal agreement, to rescind ILR from people who have it under the EU settlement scheme. It is perhaps something to keep an eye on, to stay up to date on the latest news, because we are seeing the conversation on this get more and more unusual and sort of concerning. So yeah, to reassure you, I suppose nothing at the moment, no plans to do that, and I expect that they wouldn't because, as I say, it's under the withdrawal agreement. But I think with all these things, it's worth keeping an eye on the latest news, keeping an eye on policy proposals and statements by political parties, just so that you're fully aware.
Great. Thank you very much. Again, if you think of anything later, please feel free to drop us an email. I'm going to share our contact details with you shortly. So if you need to get in touch or contact us, if you move on to the next slide, we can support you with strategic global mobility, end-to-end sponsor license management, practical right to work solutions, and employee centric immigration support. So again, thank you very, very much for joining us today. If you have any questions, again, please do get in touch. Please connect with us on LinkedIn. We also publish numerous updates, postings, newsletters, and so on. And we're always happy to have an initial conversation, whether that's any strategic planning or dealing with a live issue. So coming up next is the feedback survey. And as a thank you again for those who completed, we will enter you into our draw for that John Lewis voucher. Thank you again and have a great day. Thank you, Callum.